Mr. Chief Justice and honorable members of the court, my name is Mercer Turner, counsel for David Hendricks. I would like to reserve approximately 5 minutes of our time today to address the question of sufficiency of the evidence, reserving for co-counsel the balance of our time and the entire rebuttal. Co-counsel will address the issues dealing with the defendant's character. The balance of issues raised in our brief we submit to the court on the basis of our brief and waive oral argument on them. We suggest today that the evidence of this case is insufficient. A case based upon highly subjective expert opinion testimony drawn from an inexact science. And in this case, the science is the visual examination of particles from various types of vegetables to determine time of death, we suggest is insufficient. Vegetable analysis is not an exact science. It is not like fingerprint analysis or other commonly accepted exact sciences which are used in criminal prosecutions and are oftentimes very helpful. Here what we're dealing with is an expertise that is more closely associated with speculation and conjecture. The trial judge perhaps said it best when in the record the trial judge concluded that the case boiled down to a test of the relative persuasive abilities of the experts. In this context, the trial judge made it clear that relative persuasive abilities and credibility of the experts were not synonymous. Another weakness of the expert opinion testimony offered by the state in this case is that it is refuted by undisputed non-opinion evidence. And in particular, I'm referring to two things. First, that the weapons in the case were last used against the children. And secondly, Susan's late arrival home from the shower she was attending. The combination of these two factors indicates that almost all, if not the entire, opinions offered by the state's experts as to the time of the children's deaths was invalid. This is not a case where the expert testimony was offered in a supplementary fashion to assist the case in chief or to help the jury understand a sophisticated factual situation. The expert testimony in this case was the state's case in chief. And this is why we suggest that it is insufficient and why the court should reverse this case outright because the burden of proof was not met. We suggest that this was not a case that was appropriate to give to a jury because it is insufficient as a matter of law. At this time, if it would please the court, I would present to the court defendant's co-counsel who would address issues dealing with the defendant's character. If it would please the court, John Walsh.
Chief Justice, Your Honors, may it please the court. We appreciate your permitting us to split the argument in this fashion. You can detect that Mr. Turner and I have had a division of labor in connection with this very lengthy record, and I do wish to address the evidentiary questions that are raised by the record in this case. Now, there are two specific evidentiary issues, as you know, that were posed by the trial of this case. Both of those issues involve the state's extensive reliance on what we can telescope as character evidence or evidence of prior uncharged misconduct. The issues, I know every lawyer who appears here tells you this, but the issues are very important ones. All cases that reach this court, of course, are important, but if you're as fascinated as I am by computerization, you may have been intrigued by the fact that the issues that I raised before the court today have resulted thus far, as of 1986, in almost 12,000 appellate opinions at the state level and almost 2,000 appellate opinions at the federal level. This suggests to me that the time has come for a court, and no court has to this moment, the time has come for a court to generate guidelines in connection with the use of prior uncharged misconduct as evidence of guilt, if the courts are not to be continuously confronted by unguided efforts to employ evidence of that sort on the issue of guilt. The use of, it's understandable, given those statistics generated by a sweep with a Westlaw computer, it's understandable why the author of the leading treatise in connection with evidence of this sort refers to it as the prosecutor's delight, also pointing out at the same time that overuse of character evidence is the principal cause of reversal. We could combat that waste of judicial time in a case of this sort. I think it's also significant, Your Honors, that in the brief period between the time this court granted the petition for review and this day, both an Illinois appellate court and a federal appellate court for this circuit, the Seventh Circuit, have found it necessary to decide similar cases in which the prosecution, in understandable zealousness to prosecute, has overextended the use of character evidence and the theorizing that it gives rise to. Your Honors were good enough to give us permission to cite to it those intervening cases. The Sales case, the Illinois case, arises in the First District appellate court decision involving lay prosecutors' attempts to provide a psychiatric explanation for the conduct of a homosexual charged in a rape case. The appellate court, citing an opinion of this court, the Doherty case, suggested that it is not the role of prosecutors to engage in sophisticated, unsupported psychiatric speculation in cases of the sort before it. The Doherty case made precisely that point and gave guidance to the Sales appellate court on this question. The Beasley case, the federal case, was a drug case in which heavy use of irrelevant prior misconduct evidence was employed. The Seventh Circuit pointed out that there was a powerful need for rules guiding trial courts in making both the relevance and the prejudice determinations when confronted by uncharged misconduct evidence. And that was good from the standpoint of the appellant who appears before you today. But the Seventh Circuit then provided no guidelines. It's one thing to advise lower courts that they should adhere to principle, but the time then comes for the providing of such principles and guidelines. And that is why I say that despite the amount of litigation in this area, no court seems to have generated with any specificity guidelines. And that is why, of course, I'm asking this court to consider doing precisely that.
Professor Waltz, is there any bright line that can be drawn between the demonstration of a motive for the offense and what is purely prejudicial introduction of material?
I think the honest answer to your Honor's question is no. I think that it is instead a matter of describing with care to a trial judge what process or procedure must be employed in confronting the question. no process, no procedure, whatever was employed in this case, not even an on-the-record balancing of probative worth as against prejudice. In our brief, it's the supplemental brief, and I think it begins on page 21, we list a blueprint for such a procedure that could be employed. But if you look at the cases, if you simply address this as a factual question, there's no bright line. We may say, well, on the far side of the line, we will clearly permit evidence of a motive so compelling as to identify the perpetrator. I call it the von Bülow syndrome, and you follow what I mean. A case in which the evidence of spouse homicide charge, of infatuation with another woman is obvious and powerful, and there is even an ultimatum laid down. Be rid of your wife in 7 months or our affair is concluded. And the wife becomes comatose at precisely the expiration of the ultimatum. That, Your Honors would say, does not reflect any bright line, but it is surely far across an available line. Far short of the line is a case such as Hendricks, in which, on the one hand, the evidence is of absolutely minimal probative worth once you isolate the issue. Some, what shall we call them, games or passes of the most timid and certainly fruitless sort on the part of a fellow, offered on, I don't wish to exaggerate, but to me, no known theory of motive. So I suggest to the court the development of a procedure that shall be employed by the trial courts, which we have suggested in the briefs. One of the things that it strikes us as being important, although again it's not a bright line, is that trial judges, with the aid of prosecutors, be adjured to focus on what the precise issue is. Motive, one senses, I don't profess to have read all 11,000 of those cases, but motive evidence, that phrase, motive, well, offered, Your Honor, on motive, is fast becoming akin to, if I don't know what else to say, I will say, well, Your Honor, it's part of the res gestae. Or it's offered on state of mind. Or it's just becoming vaguer and vaguer and vaguer. You say, well, it's offered on motive. But to what purpose? Your Honors might very well say that there are two questions that trial judges have to consider. The first question is, does the evidence truly demonstrate motive? And then, since motive is not the element of any crime, the second level question is, to what legitimate elemental issue in the case does that motive evidence go? That brings one to this case. I to this day do not know what the state's theory of relevance was, but you can detect some of the changing theories. What did this evidence illuminate in the way of any element? We know it wasn't offered on criminal intent. Criminal intent was obviously not an issue in this case. There's no question about what the intent involved in this awful case was. It wasn't offered to avoid a suggestion of accident or mistake, as motive evidence sometimes is. It wasn't clearly offered to explain conduct by the defendant previously demonstrated in the evidence. We allow that. We give the prosecution an option where it has demonstrated conduct to provide an explanation for it. They don't have to, since motive is not an element, but we give them the opportunity to do so that the jury won't be baffled, and so that artful defense counsel will not be able to get up and say, well, they demonstrated that the defendant did this or that, but why on earth would he? Because there's no shown motive, which might very well confuse a fact finder, particularly one that does not focus on the fact that from time to time in this age of ours, we do have totally incomprehensible, baffling homicides. It used to be you had to go to some large metropolitan area to be mugged or murdered in your bed. Now, given what we label as serial murderers, such like, awful things happen everywhere. What was motive offered for here? Well, the suggestion has been made at one time and another that the evidence in this case suggested some kind of undefined psychotic explosion, kind of take judicial notice that under the circumstances of this case, despite the absence of any forewarning, any erratic conduct, anything out of the ordinary, there will be an inexplicable psychotic explosion. I think your honors will conclude that that stretches the concept of relevance too far. And then perhaps there is a suggestion that the motive evidence here was sufficiently potent to identify. But again, I think in assessing the question whether in logic the evidence produced did any such thing, the court will conclude that the answer is in the negative. The prosecution in this case declined at every turn to advise defense, and that's not too important, but more importantly, the trial court, what the theory of relevance was supposed to be. And it prevented the trial court from exercising discretion. It prevented the court from exercising informed discretion. Now, I think that I should move in the time that remains to me to what is really the second issue in this case. I do not know that it is any more important than the basic relevance question, but very closely connected to that initial question, the relevance question, is the question of unfair prejudice. Not just prejudice, unfair prejudice. Obviously, legitimate evidence on a side's behalf prejudice the other side in that it contributes to its burden of proof. But here we address the question closely related to the relevance question of unfair prejudice. And this brings us back, it seems to me, very strongly to Justice Ward's inquiry. Are there any bright lines? Again, I have to say that I don't think there are, or that this court should endeavor to generate any. I think only this, that again, trial courts must be advised that it is necessary to engage in a careful weighing process where evidence of this sort, character evidence, uncharged misconduct evidence, is offered on some defined theory, but also by a second line of inference gives rise to the most damaging and unfair inferences. In this case if I may say, it seems to me to be an almost classic example of circumstantial evidence that moves off into two lines of inference. One line of inference moving toward whatever the theory of relevance may have been, and a second line that moves toward unfair prejudice. The defendant in this case was made out to be, well, in opening statement he began as a deviant. It's hard for me to think of a more poisonous phrase, and it was wholly unsupported by the evidence in the case. As the evidence progressed and one got around to closing argument, he was, on the basis of his kind of milquetoast approaches to several of these models, some kind of hell-bent sexual lecher, along with religious hypocrite, and maybe worst of all, successful young businessman. The line of inference toward inflammatory besmirching of character, very powerful. In the federal rules, I know as well, I suppose, as anyone, that Illinois has not adopted, and I have to admit I hope it doesn't adopt, the federal rules of evidence. But under the federal rules of evidence, there is a procedure, the Rule 403 procedure, at jury trial judges to balance probative value and potential for unfair prejudice. Actually, the federal rules were latecomers because this court, in a number of its opinions, has already gone that far toward a set of guidelines. There are many opinions of this court that antedate the federal rules of evidence requiring such a balancing test. There was no such balancing in this case. The character evidence, as I look back at this court's opinions and other opinions, the issue that we address today has arisen in cases in which there was a small amount of character evidence followed by a very limited amount of argument, a few lines of the transcript. And yet, often in cases involving the most reprehensible sorts of defendants, this court and other courts have been sensitive to the rights of the defendant, to a fair trial. These past opinions have come down in cases involving Beasley as a drug dealer, sales involving homosexuals, the Funches case cited in our briefs, a conceded car thief, and yet we protect the rights of such as we should to fair trial. Here we have a case in which the character evidence was virtually the whole case. As your honors know from a look at the record, it spreads through volume after volume after volume. There were 30 witnesses, not as to physical evidence of criminal conduct, 30 witnesses as to the man's character over the years. And page after page after page of transcript of closing argument exaggerating that evidence and imposing upon it a pseudo-psychiatric diagnosis. I honestly suggest to this court that it reconfirmed Doherty's suggestion that the felony courts are an inappropriate forum for amateur psychoanalysis. The evidence in this record did not support the extended argument that there was some sort of psychotic explosion in this case. But the crucial point is the one, I suppose, that the judge in the Seventh Circuit case was attempting to make, the intervening case that we have cited, and that is that there must at least be guidelines. There must at least be a procedure adhered to. If the procedure for making these admission of evidence decisions is adhered to, there will not be much left for a high court to review. If the procedure is employed, procedure laid down by this court is employed, then of course the result of the implementation of the procedure lies within the realm of discretion. And it is very difficult to second guess an exercise properly implemented of judicial discretion. But here we have a case in which the process preceding the exercise of discretion was faulty. The second branch of this case could be resolved by a clear requirement of a balancing test between probative worth and potential for unfair prejudice. There was no such procedure implemented in this case. Indeed, it's fascinating because the record of the trial judges agonizing in connection with all of this evidence is really so clear. Never could he discover the theory. He had to keep making conditional rulings, hoping that eventually things would be connected up. And as he went along, on the record, he said, I don't even think if you establish these other things, his religiosity, his affluence, and so on, I don't think even if you establish these other things, that this evidence of character can stay before the jury. And he never acted upon that feeling. And at another point, he said, I recognize that this evidence poses a legitimate concern with respect to unfair prejudice. But the balancing process never took place. Under the guidelines that we have suggested, and I dare say this court can thoroughly improve upon them, but at least the suggestion is made that there is room here for case management. The trial judge, in assessing the evidence and its probative worth, could consider whether we really needed a parade of 13 models in this case. If your honors will put those models back in chronological order, which they seem to have slipped out of on appeal, you will see not much of a pattern of anything. And you might inquire, was it really necessary to parade 13 of them before this court? A trial judge could conclude the answer is no. Too much. The case will be out of balance, and we will limit the number of witnesses, or we will limit the detail with which such witnesses will testify.
Professor, I'm sorry, but your time has expired.
I'm sorry, I did not notice the light, Your Honor. Your Honors, we ask you to provide guidance to the lower courts and dispose appropriately of Mr. Hendricks' case. Thank you very much.
Intends to show the children's time of death as our primary evidence. And he's also argued that we relied primarily on the motive. Well, in fact, we relied on both, and we relied on many other things to show his guilt. There's no question here that Hendricks is a very intelligent man. He was a man who had all the time and resources he needed to try to commit a crime, the crime being to kill his family in a manner so that it couldn't be detected, and he would never be found guilty. Well, despite that, despite his intelligence, his resources, and his time, he made crucial mistakes. And one of his mistakes did involve the time of death of his children, and another of his mistakes was that he didn't realize that the authorities would link up his conduct with these models and compare it with his alleged religious beliefs. Now, I think in light of these factors, the other factors, most specifically the fact that he didn't properly stage a burglary, the fact that he didn't act convincingly in Wisconsin on this alleged business trip, and the fact that he didn't act convincingly when he came back show in a clear and convincing fashion that he was guilty. Now, I'd like to deal with one point that is crucial to the briefs, and it's a very brief point and wasn't raised today, and that's the defendant's argument that, in fact, the trial court's finding at sentencing that he wasn't going to sentence Hendricks to death because he wasn't necessarily convinced he was proven guilty is tantamount to an acquittal. Well, of course, that's not the case. At the same time he made that finding, the trial court found, and I quote, "I have already determined that the totality of the evidence was legally sufficient to reach the jury for its consideration, and this continues to be my conclusion today," end quote. Well, the point is then that he wasn't in agreement with the jury's verdict, but in fact the evidence was sufficient to go to the jury. I think that's interesting in light of the fact that that's the precise standard of review that this court must use, the standard set forth in Jackson versus Virginia and adopted by this court, of course, in Collins, reaffirmed in Linscott, and Sanchez, and other cases. So we know we've got that precise type of review once by the trial court. We've got the precise type of review by the appellate court, and I would encourage this court to reach the same result. Now let's look first at the evidence of time of death. We know that Hendricks took his children to the pizza parlor, ordered a pizza at about 6:30. We know that normally that pizza would take 10 minutes, and so we know that they ate around 7, perhaps before. His testimony was 7, and I'll accept that testimony at 7 o'clock. Well, we know that he claimed that he left the house. We know he told Beverly Crutcher he was going to leave at midnight, and we know, in fact, when he returned, he told Detective Crow he left at midnight. So the question then is whether, in fact, those children died before midnight. If those children died in that 5-hour time span, then, in fact, Hendricks is obviously guilty. Now, there's the argument made that mere presence is not enough. Well, of course that's true. But in light of the fact that these children were butchered in their own house, if Hendricks was in the house, he's obviously guilty. I think that's pretty obvious. Well, when the autopsies began on the children, something unusual occurred, and that was the fact that there were the food contents in the stomachs appeared to be completely indigested. It looked like, in fact, they apparently ate and were killed. We presented experts to show that, in fact, they didn't have time to digest that food, and since we know they ate at 7 o'clock, if in fact they died before midnight, obviously Hendricks is implicated. Now, our evidence showed, and they were highly qualified experts, these experts agreed that we couldn't pinpoint. No one ever pretended that we could pinpoint time of death, and no one ever tried to pinpoint time of death. The point was that they died sometime before Hendricks left. And Dr. Davis, Dr. Baden indicated that they died sometime between 8:30 and 11:30. Well, I think the interesting thing about that is Dr. Baden testified he thought 9 o'clock. So he thought they died early. He would go as far back as 11, but probably not. He thought 9 o'clock. And lo and behold, at 9 o'clock, somebody saw Hendricks leave the house. Well, I think it's pretty obvious that he of course denied this, which is a credibility question that's been resolved against him. But, it's just too coincidental that suddenly he leaves the house at the same time that our expert says, in fact, he probably killed those children around the same time. Well, in light of the fact that evidence was obviously disposed by the killer, I think it's just too coincidental. Now, the defendant makes the point that it's inconsistent with our theory that the weapons, the blood found in the weapons, was that of 2 of the children, when our theory was, in fact, that Susan, his wife, was killed last. Well, I think if this court reviews the record, it's certainly very possible that a man as intelligent as Hendricks may well have set this thing up. He may well have killed the children, and I think in all probability he did kill the children. Killed Susan. We know that he wiped off all the instruments and gone back and put blood on this axe. That is certainly not beyond the realm of possibility. And I think that, of course, was something for the jury to decide, and we know how they decided all of these issues. So, in fact, there was a battle of experts. Our experts, highly qualified people, testified, didn't try to go too far, didn't try to pinpoint, freely admitted they couldn't pinpoint, but they put Hendricks in that house before he, in fact, claimed that he left. Now, I think the very interesting thing is, and again, this goes to the type of man Hendricks is, Hendricks said he left at midnight. Well, he certainly was smart enough to realize later that the earlier he left then, the less probative the evidence of time of death. Well, then suddenly he changes his trial testimony is that he left at 11 o'clock. Well, again, he told Beverly Crutcher he's leaving at midnight. He came back as soon as he got back to the house, he said midnight. But then he's smart enough to realize that's a mistake. I better try to convince the jury of an earlier departure. Well, in fact, then he tried, and again, a credibility question, again, resolved against him that shouldn't be disturbed by this court. Now, I think another key point is the staged burglary. Now, we presented evidence that, in fact, this was a staged scene to make it look like a burglary. Now, obviously, the defense theory is that, in fact, the burglary had gone bad, and apparently the children and or Susan were alerted to the presence of the burglars, and the burglars felt compelled to kill them. Well, the evidence just doesn't support that in any way. In fact, nothing was taken. And I think the interesting thing about that is when the police asked Hendricks what was in the house that was of value, well, I'm sure he thought, well, what would a burglar have wanted? And he said, maybe some cash and a microwave. Well, in fact, that house was loaded with valuables that are the precise type of thing a burglar takes. Small appliances, cameras, bicycles, all kinds of things. Well, obviously, Hendricks didn't realize that those were the types of valuables that burglars want, or in fact, he in all probability would have changed his story. So we know nothing's taken, and we know that we have a defense theory that would require us to believe that a burglar got into that house, went into the garage, took an axe from the garage but didn't disturb a single other thing there, went into the kitchen and pulled out a butcher knife, didn't disturb anything, went up and butchered these victims. Well, that just doesn't make any sense. It is so unlikely that in fact it points directly at Hendricks. Now we know there's no sign of forced entry. We know that Hendricks originally said he locked the doors when he left. Well, in light of the fact that there's no forced entry, he changed his story to, well, I usually lock the doors, but I'm not sure. Well, again, Hendricks is a bright man. He obviously realized that in fact, without making it appear that there was a forced entry, the only person that it points to is him because in fact he said he locked the doors. Well, again, he denies making that statement, but in fact, again, credibility resolved against him. Another crucial aspect of this staged burglary scene is in fact, the fact that there were no defensive wounds on any of the victims. Well, if in fact they were alerted to the presence of burglars, it's only reasonable to believe that they would have had defensive wounds of some type. Well, that didn't happen. What happened was whoever killed these people went in between the beds of the children and butchered them. Went into Susan's room, pulled the covers over her head, and did the same. It's absolutely inconsistent with in fact these victims being alerted to a burglary. In addition, we know that in fact there were drawers, there was blood spattered all over on the outside of drawers, not on the inside. Well, if someone's in the room going through the drawers and in fact the children wake up, Susan wakes up, and they're forced to kill him, in fact the blood's obviously going to spatter into those drawers. Well, it didn't happen. Susan had purses, blood on the outside, none on the inside. The point is it's consistent with a staged scene. They're killed, and then Hendricks made it appear to look like a burglary. Now, the other thing that's obvious is he didn't even ransack the entire house. If, in fact, these people killed the victims to in fact not be detected in the burglary, well, you would think that, in fact, they would take something and go through everything. Well, that didn't happen at all. The evidence of blood or absence of evidence blood being tracked through the house is also crucial. We know there's blood in the bathroom. Well, if these are people who simply butchered Susan and the children, you would think they would drag blood throughout the house. Well, it didn't happen. The only evidence of blood is, of course, at the scenes, on the weapons, and in the bathroom. Well, it's pretty obvious what happened. He went in there and cleaned up and did a good job of cleaning up. So we know there's no forced entry, there's nothing taken, no defensive wounds, and in some areas of the house not even disturbed. Well, we presented evidence that, in fact, it was a staged scene. Hendricks presented evidence that it wasn't. obviously, every fact points to the credibility of our witness. I think it's very important that in Hendricks' television interview after the crime, he in fact said, well, apparently there was a burglary inside. No one had told him. He hadn't been inside the house, we know that. And we also know that no one told him that there was a burglary that had occurred. In fact, he can test that, but again, that's a factual question. That's been resolved against him, and the record fully supports the finding. We know that Hendricks' conduct on his alleged business trip wasn't consistent with a real business trip, a sales trip. We know in the first place that his travel time was off. Well, in fact, if he left at 11 o'clock, if he reached the Hardys in Stevens Point at 7:17, we're talking over 8 hours. Well, the test drive, in fact, amounted to about 6 hours and 30 minutes. And of course, this includes the stops that he claimed. We will give him credit for those stops that he said that he made on the way. Well, so we're talking about an hour and a half or so, which suddenly puts him back in the midnight range, the original time that he stated. We know that Hendricks didn't try to make any sales up there. In fact, he discouraged a sale to a woman who wanted to buy a brace from him. We know that he lied about passing through. Supposedly he's on a sales trip, and he starts telling people on at least 2 occasions that I'm merely passing through the area. I'm on an extended vacation. Well, I think that lie is crucial. We know he lied about not having a model of the brace. We know that he lied about his license number, and we know he lied about the fact that he called home at 11:30 a.m. He said he used his calling card for all the calls, and in fact, there's no evidence of that. There is evidence of all the other calls that he made. We know he dashed from place to place. We know that even though he called home and the police told him there are no accidents reported, that in fact when he checked out he said there's an emergency, I've got to go home. Well, the whole thing was a setup. He made telephone calls to get someone else to go over to that house and discover the bodies. Every piece falls in place. Every single piece. Now we also know that when he learned of the murders, his conduct was not consistent with the
May I ask just one question about the pieces? That is this, either Mr. Waltz, I believe Mr. Waltz said that there was evidence that the wife did not return home until 10:30.
10:33, I think, is
Yeah. How does that fit into the time schedule of the children being murdered at 9 o'clock?
Well, obviously he murdered the children first and murdered Susan after she came home. I think that's the most obvious fact from that, and there's no reason not to believe that. We never tried to pinpoint her time of death with stomach contents. It was only the children, and that was the key. Susan apparently ate, went home, and based on the test drive, would have gotten home at, as I said, 10:33, and that's consistent with Hendricks' testimony. But we never tried to pinpoint her time of death with stomach contents. Only the children, and that's the key. Hendricks makes the argument that in fact...
And you dispute the statement, the evidence showed that the children were murdered after the wife.
Oh yeah, I think it's clear the children were murdered first, and I think that's why it's important to note the distinct possibility that Hendricks took that weapon back in and put blood from the children in it after killing Susan. That's not at all beyond the realm of possibility in light of this the type of man and the intelligence that he obviously had. When Hendricks learned of the murders, he comes back and he's told about the murders, and his response is, in essence, they're better off now. He's not upset. He doesn't break down. Within a day, his primary concern seems to be that the person who's butchered his family is going to have their soul saved. Well, I'm certainly not criticizing those types of religious beliefs, but they're just not consistent with a person who's just had his family butchered. And I think the crucial part, the crucial aspect of those statements is that what Hendricks was trying to do, and this brings me into the motive question, what he's trying to do is make himself appear to be too righteous. In fact, we know that if Hendricks had been willing to, for example, abandon the religion, he wouldn't have had the problem with the models. Well, he didn't want that. He wanted to be in the highest standing in that religion. That was extremely important to him. Well, his reaction after the murders, I think, contributes to that. So let me address the motive evidence. And I think that defense repeatedly refers to this as character evidence. It's not. It's motive evidence. That evidence was introduced solely to show why Hendricks might have acted. And I think the law in this state is perfectly clear that that's a proper reason for using the evidence. Now, the evidence of his conduct toward these models was important only because we also put in the evidence of his alleged religious beliefs. And it was the conflict between those two that was so crucial. That's what explained the motive. Not merely the fact that he was making these advances toward the model, not because he had this increasing series and pattern of aggression toward the models. It was because that evidence showed a conflict with his alleged religious beliefs. Now, clearly, that evidence was never admitted to show propensity, and that's where the defendant's cases fall down. Sales, Beasley, Funches, etc. When we entered evidence of a crime that's similar to the charged crime, well, then, in fact, that's propensity evidence, and there are problems with that. In fact, that is prejudicial to the accused. Well, that didn't happen here. That clearly didn't happen. It was misconduct considered in light of the alleged religious beliefs that, in fact, showed a reason. Now, I think the most obvious way for this court to review this
Are you saying that would not have been admissible if he had belonged to a different denomination?
I think that if we had not used the second aspect, those religious beliefs, something that showed conflict, I would agree. The evidence of the advances toward the models alone was insufficient in this case.
Mr. Graham, the advances toward the models suggested, according to your thesis, the motive for his killing his wife, let us say.
Mm-hmm.
What evidence was there of a motive for killing the children?
Well, I think that's a good point, Your Honor. I think the evidence was simply that in fact, for Hendricks to go on and continue this pattern, it would have been very difficult for him saddled with these three children. Clearly, he was having something occur in him, some type of awakening that was causing him, and I think that's where the increasing aggression in his conduct shows. He was clearly becoming more aggressive towards models. I'm not sure where his pattern would have gone in making these advances, but a person like that, saddled with these three small children, and of course, then he would have been tied more closely to the religion and to the religious group, and that would have been a real problem for him. The point was that in fact, Hendricks, he wanted to remain in good standing in the religious group, but he had to somehow get separate in terms of being allowed to act. And to have those three children was a real problem. And so once in fact he killed Susan, I think it's clear that he had to kill the three children. Now,
did this religious belief permit him to continue his conduct toward the models if he didn't have a wife and children?
No, it wouldn't have. But the point is, it would have been a much lesser chance of being discovered if he would have had no family. But no, that certainly wouldn't allow that type of conduct. And I think that it's important to characterize this conduct, and especially the increasing pattern of aggression. But let me make one point about exactly what the evidence was used for. And in closing argument, when the prosecution told the jury why the evidence came in, it argued, and I quote, "We are not trying to say that any man who goes out and is temporarily unfaithful to his wife is going to run out and kill his wife and kids," end quote. Well, that's the point. So, in fact, the prosecution never used that conduct to show that he'd kill his wife and kids. It was the conduct in light of the alleged religious beliefs. And that's the key. This wasn't propensity evidence in any way. And I think the argument that, in fact, a jury might convict this man of butchering his family because he was making passes at models is just, it's so implausible that it's really got to be discarded by this court.
Aren't there many religions that would discourage that type of conduct?
Sure.
Why was this religion so special that would motivate the person in this instance to kill his wife, and because he had this aggressive attitude?
It could have been a member of any of those other groups. But the thing that's special about this group is this was a real fundamentalist religious group, extremely fundamentalist, a very small, tight-knit group in that area. That's the real distinction. I think it could have been anyone who held these beliefs or alleged to hold these beliefs so strongly would have qualified if, in fact, the prosecution could show that it was important for him to remain in good standing. But the real interesting thing about this is it was a very small, tight-knit group, and that's why it's different, and that's why it's so probative. It would have been very difficult for him to remain part with his family in this group and carry on this conduct. So the beliefs could have come from anywhere, but this is a special case. Now, in regard to his increasing pattern of aggression, it's clear that in fact that's very relevant. And the other thing that's very important is the fact that he started to admit his religious doubts to these models. Now, we know that his pattern went from, we know that there was some innocent, seemingly innocent conduct towards some models, and that was introduced to show that Hendricks didn't have to undress these models. He didn't have to draw all over them with a felt tip marker. He didn't have to massage their backs and breasts and all sorts of things to get this brace on them. So that evidence comes in to show what, in fact, the conduct that was acceptable and proper. We know there's evidence from another expert that it takes about 4 minutes to fit this brace, and Hendricks has these sessions begin to get longer and longer, and in fact, then he begins to make advances at them. The advances at, for example, Lee and Wilmoth are clear. He suddenly gets them down. He's got them laying down. He's putting substances on them, and then he in fact tries to kiss him, tries to embrace him. Clearly, he's taking a step. Later on, he realizes that in fact, if I tell him I'm a doctor, I can get him to undress very easily. He does that. In fact, then, I think it's important to note that he's told, for example, Carla Webb, after being rejected, that he's a good Christian, and the crucial thing to him is his wife can't find out about what he's just done. Well, that shows the conflict to me, clear as could be. Later, when he's out in Arizona, he tells Libby Tomlinson that he has doubts about his religion. Well, the conflict is becoming greater and greater. That's the last instance before he kills his family. I think the only logical conclusion is that, in fact, he can reconcile these beliefs with his conduct. Now, I think that a couple of crucial points here are when we talk about balancing. In fact, the trial court here did balance. The trial court excluded one witness because, in fact, the court found that it didn't fit in. So the trial court didn't just let the prosecution put in any witness it wanted. I think it's also important to note in terms of the overkill argument that not all of the models testified about his aggression, but in fact the prosecution showed that there was innocent conduct and proper conduct, and then showed later it goes to making the advances to the models, it goes to telling them he's a doctor, and in fact goes to expressing his religious doubts. So, in fact, we know the evidence is highly relevant. Well, the question then is, and I guess I'm in disagreement with Professor Waltz, I think it's clear that in this state, in regard to admitting this evidence, if the evidence is relevant, and it obviously is for these reasons, then the question is whether the probative value is outweighed by the prejudice. Here, where in fact we're not trying to show propensity, then there's no prejudice. It is, as I've said, it's simply unbelievable to think that this jury would convict him of butchering his family because he made passes at models, unsuccessful passes at models. That just wasn't going to happen. So in fact, if the jury accepted the testimony, and apparently they did, then it was highly probative and not prejudicial. And in fact, if they rejected it, which of course I'm only speculating, we have no reason to believe they did, then in fact it's simply meaningless in terms of the murder charges. And that's what we're dealing with, murder charges. I think it's interesting to note in Sales that the defense talks about, it's sexual conduct in a sexual case, rape is alleged. In Beasley, the Seventh Circuit case, it's drug-related conduct in a drug prosecution. In Funchess, it's prior convictions for the same precise type of charges on trial for. Well, in all of those cases, there was no exception to the general rule of no misconduct. And here, we weren't using that evidence to show propensity. That's the absolutely crucial point in regard to the motive evidence.
But in fact, it could have had a tendency to do so.
I don't think there's any way that it could have attributed to a finding that he would kill his family in this brutal fashion.
Well, isn't there the very grave danger that the jury may just have omitted this one additional step that you're asking to put in there, consider this in conflict with your religion?
Well,
said, yes, this dirty philanderer, he must have done it.
Well, I don't I don't see how. I guess I don't agree that the jury would have taken that step, but I especially don't agree in this case because every time his conduct toward the models was stressed, the conflict within him in regard to the religious beliefs was stressed. They went hand in hand. And that's the crucial aspect of the case.
Well, when you combine it with the religion and the jury had the religious aspect as well as the philandering aspect in mind, might that not have exaggerated the prejudice the jury might have felt toward this defendant? Because here he's not only a philanderer, but he's not following his religious beliefs. He's a faker religious-wise.
Well, I think that if in fact that's the case, it also accentuates the conflict within him, and therefore the probative value. And then, so if it was going to happen, then our proof and the relevance becomes stronger. And in fact, if that were to occur, that's even more reason to admit it.
But how do you weigh the possible prejudice against the possible probative value?
Well, I think that's something that the trial court's got to do in light of all of the evidence, in light of all of the motive evidence. And I think that once it's shown to be relevant, it becomes the defendant's burden to show that the prosecution is not entitled to admit relevant evidence because of the prejudicial value. And that's simply the showing that he didn't make here. I think it's a balancing test, and I think it becomes his burden at that point.
But is that perhaps what influenced the judge to express his own doubts about the guilt in the sentencing?
No. I think there's no question that he simply wasn't as convinced, and I think he's absolutely wrong about this. There's no doubt he's wrong. He wasn't as convinced about the time of death, I think. Regards to the supporting evidence, he just wasn't as convinced as the jury obviously was. I think it's clear that was it, and not the motive point. Your Honor, for all these reasons, we think it's clear that despite the fact this is a circumstantial case, every piece of circumstantial evidence falls right in line. We think the trial court's evidentiary ruling was correct, and we would ask this court to affirm the conviction of the appellate court and the circuit court. Thank you.
Thank you, Mr. Graham. Professor Waltz.
Chief Justice, it's obvious that my peripheral vision is no good. Do I have a few moments left?
You have 10 minutes.
Having run over earlier.
Oh, yes, you have 10 minutes.
Thank you very much. I would like, I'm always fearful of rebuttal being non-productive, but I would like to join in response to a few of the questions that were asked. If I may, Justice Simon, you'll recall having inquired about the time sequence here, which is really quite important. The state's case resting on such a tiny factual pivot of an upside-down pyramid, it's very crucial to the state that the children have been murdered first. And of course, on that point, they rest exclusively upon the willingness of an expert to testify that precise time of death, 9 o'clock, can be based upon the reading of stomach contents. But putting that aside, in response to your question, I'm sure Your Honor will have noticed that the state's theory depends upon the notion that this mother, all the evidence showing her to be an extraordinarily devoted mother, came home to that house and was induced to go to bed and there be murdered after the murder of her children without her having, in accordance with her invariable custom, looked in upon the children before she went to bed. I believe that as you listen to the state's argument with respect to the facts in connection with sufficiency, you could detect how much is based upon innuendo, speculation, and conjecture. We must even speculate that this defendant, in order to alter the sequence, would think to place the blood and indeed the hair of one of the children upon the weapon. Well, the trial judge's comment. I mean, it's one thing to say that one disagrees with the judge's comment, but here is a trial judge who was present and heard the witnesses and saw the witnesses, and he said, in his view, the evidence was insufficient to convict. If nothing else, whatever that message to the High Court may be, if nothing else, it is that this was the closest of possible cases. And close cases, this court has said it, close cases must be error-free. And this case, with its mountainous and dubious character evidence, offered, I call it bad man evidence. We can't, by physical evidence, link him to this crime, so we will show him to be a bad man. I notice something missing in the state's brief on appeal, which is virtually a copy of the brief filed in the court below, but for one sentence, which has been removed, and it is apropos to the questions put by more than one of the justices. This line appeared in the brief below. Religious beliefs have caused many homicides. There is, of course, no footnote, no citation in support of that specialized intelligence. The state does not seem to want to confront the fair trial issues along with the sufficiency issues in this case. But we rest assured that this court will. Thank you very much.
Case number 63803, People of the State of Illinois versus David Hendricks, taken under advisement as agenda number 7.
8.
Agenda number 8. Mr. Marshall, the Supreme Court stands adjourned.